skyrocket, and it's really, really, really bad. Okay, so the problem with this case is what happens if the Supreme Court wants to say, oh yeah, subsidies are limited to states with exchanges? That creates the very adverse selection death spiral Congress tried to avoid. So the courts may say is, you know what? To avoid this constitutional difficulty, we will read the statute as allowing subsidies in all states. In other words, like the court did the first go around, they may avoid the constitutional issue altogether by ruling on this narrow statutory grounds. So even though this is not a constitutional case, the Constitution very well may come into play in resolving it. This was not anticipated, but there were a number of questions by Justice Kennedy, who is our lawgiver, our Solon of the modern era, who tells us what we can do. And he asked a number of questions which strongly suggested angle will be there. So I was there yesterday. It was a very interesting argument. I think I'll talk a little bit more about it today when we discuss the 11th Amendment. But it was a very good case. And I think at this point, our predictions is a total toss-up what's going to happen next. I don't know. It's really too close to call. Okay. By the way, my tablet's not turning out, so I have my lecture notes on my phone, which is why I'm looking at my phone. I promise you, I am not texting. I always have backup, at least 2 devices. No paper though. I actually discovered something. So yesterday I was trying to take notes during the hearing. I can't write anymore. I couldn't. I mean, I was able to make scribbles, but like I couldn't even read what I was writing. I was like, okay, let me, because the Supreme Court is one of the few places in the world you can't bring any electronic devices. Nothing. No cameras, nothing. You pen and paper. Actually, up until about a decade ago, you could only bring pencil. They actually changed the pencil policy like 10 years ago. I'm not joking. This is actually a thing where the reporter insisted we want pens, and they let them bring pens. Anyway. All right, so this is kaput, so I'll go back to Plan B. Okay, so any questions before we get started on anything we covered last week? Okay. Reminder, I'm sure you already know, your outlines are due to me Sunday night by midnight. That means 11:59 on Sunday, not Monday. Sunday by 11:59, okay? And I'll go over at the end of the class a little bit more I'm looking for. But about a handful of you have actually showed me draft outlines, which I think are more or less the right direction. If you haven't, it's getting to be probably close to being too late for me to look at it before Sunday. But I encourage you to, in emails, I can respond. If you send me something by like, oh God, by like tomorrow, I'll probably get back to you by Saturday, but that's about the latest. So by tomorrow, like afternoon around like 12 or 1 o'clock, that's about your cutoff. After that, I can't promise I'll respond to anything in time, but I'll do my best, okay? Any questions on that? Okay. All right, let's get started then. Yes, sir.
Are you going to go over what you're looking for in the outline?
Yeah, that'll happen today.
Okay.
Yes, sir. I mean, we discussed this over the past couple weeks, but I'll do a little bit more about it today. Actually, if you want, I'll to quell your anxiety, I'll lead off with that, and that way we don't run out of time. So the general gist of the outline, right? Here, I anticipated this would happen, so let's do it at the end. I'll do it now because you want me to, right? So you have, Roman numeral 1, letter A, number 1, right? Everyone learned this like in elementary school, right? This is about as deep of the outline I'm looking for, right? You should have a couple main parts, right? So, part 1, introduction, right? Part 2, facts, okay? Obviously, your headings should be a little more substantive than this, but these are the general gist I'm looking for, right? What are your facts? Well, what are the statutes, precedents, rules, right? What are the various doctrines that you're basing yourself on? And this was in the reading for today from the Volokh book, but I find that all too often law students obsess with the facts section because it's easy, because the stuff's already there. You can just write these really long summaries of all the cases and the summaries of statutes. I don't want you to do that, okay? I already know what the cases are. I know what the statutes are. I want you to focus on the harder part, which is going to be number 3, which is more or less your claim or your analysis or your opinion or however you're framing it, right? The third part should be, what is it new that you're bringing to the picture, right? What's your insight? What's your thesis? What's your opinion? Why did the court go wrong? What did the court miss? What could the court should have addressed, right? This is where this is where you shine. In terms of Iraq, right, this is your A. Everyone likes the I and the R because that's easy enough, but the A is where you always struggle. This is your A. This is where you have to prove to me that you're law students. You're going to be lawyers in a couple years, and you're able to actually make cogent arguments about why something is right or wrong or whatever it happens to be. And you're going to need a couple subparts, right? Because usually arguments have a logical flow to it. You build up, like, here's your basic premise. Here's where the court went right or wrong. Here's what I think should actually happen. So you build your argument right within this one, okay? So, I gotta think of an example. So say you're doing something like on, Obamacare. I'll make it easier, right? So you say something like, let's talk about, the court's saving construction. So in the Obamacare case, the Chief Justice said, it's really not a tax, but pretend it's a tax to uphold it, right? So you can introduce, okay, so here's a saving construction, right? Here's what the Chief Justice said, right? This is why it is wrong. This is why you should not apply the saving construction. If the court finds the statute is unconstitutional, it should invalidate it. Okay. Here's what it should have done, right? The court should have looked to the actual Constitution. If it found a violation, invalidate it. Policies be damned. Don't worry about the other consequences. Okay. And then here's my suggestion. Going forward, right? In the future, the court should follow this precedent and always confront the constitutional issues. This is a very simplistic one, but I want to demonstrate an easy one of a case we studied last week or the week before. Okay, and then usually you have some sort of, and you don't have to be married to this 1 through 4. I don't really care about the numbering. These are the parts, but some sort of conclusion, right? Like where do we go from here, right? What comes next? What does this actually mean? Put it in a context of what did you actually resolve by this paper, okay? I don't want you to give me exactly this, but this should, I know some of you probably will, but this is more or less how you should think about the outline, right? But I want most of your stuff to be in 3. This is where I want the bulk of your analysis. And if you have any questions, go through the Volokh book, right? Go through the chapters I've assigned so far, and it will give you various ways to construct an argument. This is the part I can't do for you, which I know is frustrating, right? You want me to make the argument for you. I'm not going to do that for you. I can guide you in one direction or the other, but you need to actually understand how to make an argument. And this is something which you probably maybe have never done before. Taken cases and pulled an argument out of thin air. It's not easy. The first time you do it, it's going to be really hard. But I promise you, each subsequent time will be a lot easier. Even if you've come talk to me during office hours, you see talking about it for 20 minutes or whatever, it's like, oh yeah, that's it. That's the thesis, right? Oh, that's the idea. You need to give us time to digest. So I hope that you even think your theses were due a month ago. So you've had your thesis a month to think about. So at this point, the outline should flow naturally. If it doesn't, you'll be in trouble to get the deadline. And don't be surprised if I send something back to you saying you got to redo this, which probably will happen for some of you. But I want you to at least give it a really solid effort before spring break to put this in. Okay? Yes, ma'am.
If we put optional intro to do the Saturday.
I don't have the calendar, but that sounds right.
Okay.
Yeah. Yeah, and again, the way that works is I want you to write your introduction early. If you write your introduction early, you get an additional 10 days to write the paper. This is my nudge. This is my incentive to you. If you write your introduction early, you get more time to write the paper during finals period. Because I know if you wait till finals period, you're going to be in trouble and you're not going to do a good job. So if you do it now, you'll be in much better position. But your choice. Your money or your life, right? False choice. Thankfully, we're not subject to the coercion doctrine, else I'd be in trouble. Yes?
How much time should we spend on citations?
If you want to put citations, that's great. I'm not expecting them. I mean, if you just give me the case name, like, South Dakota v. Dole, 1986, whatever, that's fine. But if you want to do citations now, you'll save yourself time later. The more you do early, the more legwork you do now, you're going to make your life so much easier when you get to it. Because that way you don't have to look up twice. If you have the case in front of you, get the citation, right? Put a footnote. You can put footnotes in outline. There's nothing wrong with that. I saw another hand somewhere. Anyway, so you have this. This is more or less what you want. Look at the Volokh book. They have some ideas how to structure papers. I'm not married to any one specific style, but at the minimum, you should hit these points. Okay. And I want to make one point really clear. If I told you last go around your thesis wasn't tight enough, make sure in your outline you give me your thesis again, make it tight as possible. Because for a number of you, I said tighten your thesis, and some of you did, some of you didn't. At this point, you need to have your thesis tight, like 3-4 sentences. If you need more than 3-4 sentences, you don't have a thesis. It's a ramble. I want you to put it as concise as possible, which proves to me that you can say your thesis easily. And if you can state it simply and concisely, it means you have a thesis. If you can't, it means you're rambling, and I don't need ramble. You understand? Questions? Anyone? Once? Twice? Yeah.
My only
Ah,
question then.
so
Sorry.
close.
For next class, it just says discussion of the paper. So are we meeting to discuss?
Right. So what's going to happen is after I get your outlines, I will probably email you, but also I want to take some time in class to actually go over the papers. So if you look for I'll bring it up here. My tablet's not working. So if you look at this, the assignment for next class, that's going to be the class of the 12th, right? You'll see that we don't have any case reading. So my goal is to actually discuss feedback, general feedback from everyone's paper, and I'll try and meet with each of you during the class briefly to go over your topics. That's why I want your papers done this week so I can go over in class next week. Okay? Good? Okay, let's go back to the substance then. Okay, any other questions? All right, well, good luck with the papers. So our topic for today is something which, if you took me for ConLaw, you studied, but if you didn't, you probably didn't, which is the 11th Amendment and sovereign immunity. Now, this is actually one of the few topics that's actually relevant for most civil lawyers, because no matter what field of work you get into, at some point, you're going to have to sue the government. Education law, disability law, insurance law, civil rights litigation, whatever branch of work you want to do involving litigation, at some point, you're going to need to sue the government. And in order to sue the government, you need to contend with something called sovereign immunity, which is a topic we'll discuss today. But more or less, the Supreme Court has construed that the states are sovereign and they can't be sued without their consent. What I want to explore today is the history of that doctrine, where it came from, how the Constitution was amended to try and resolve that, and how the Supreme Court in recent years has limited the ability of Congress to waive state sovereign immunities. Okay? So before we get started, right? That was just go around. What are the major limitations on the state's police power? What are the major limitations of the state police power?
They cannot police or enforce anything outside their boundary, state boundary, as in citizen of another state.
Okay, good. What else? But in terms of federalism, what's the major restraint on the state's police power?
The commerce among states.
Okay, good. So they can't interfere with interstate commerce.
Yes.
What else?
Foreign policy.
They can't engage in foreign policy. Good. What else?
War.
Yeah, they can't. So the Confederacy tried that wasn't allowed, right? So what else? What else can they not do?
Treaty with another.
Treaty. Okay, good. Okay, right track. Angelina, what else? What other limits exist on the state's police power?
I don't know, outside of what you mean.
What if Texas passed a law banning flag burning, which they did? What's wrong with that law? Texas passed a law criminalizing flag burning. Isn't that part of its police power? Aren't they protecting people from immoral, hatred? What's wrong with that statute?
Well, I don't know if that would have to do with terrorism. That would be something
No,
no?
Texas passed a statute banning flag burning. What's wrong with that? It's part of the police power, no?
That's for speech.
Right. So we have the First Amendment. But what does the First Amendment say, Lacey?
Congress shall make-
Congress. Congress. Where do we get? Is Texas Congress? So how come Texas can't ban flag burning as they tried to do?
Because it's implied that it's a constitutional rule, and it's going to be, it's going to be a constitutional state.
What federal statute? Why does the First Amendment says Congress? It says nothing about the states. Kelsey? Why can Texas not ban flag burning?
Because would they be overreaching and stepping into like what the federal government is?
It's a federal flag?
No, it's a flag I make it myself. Why can Texas not ban? What 14th Amendment? What's in the 14th Amendment?
That applies the Bill of Rights to the states.
Where do you see that? Here, I have it up here. Where in the 14th Amendment is the Bill of Rights applied to the states? Where do you see that? I don't see it. Anyone? Right there, 14th Amendment.
No state shall make or enforce any law which shall grant the privileges or immunities of citizens of the United States.
Where's the Bill of Rights? I don't see it.
That's not the Bill of Rights. I'm just saying no state shall make or enforce any law which grant the privileges or immunities of citizens.
What are these privileges and immunities? Says who? No. See, actually here you're wrong. You're actually right, but the Supreme Court did not say that. So the short answer, right, is the 14th Amendment. Says, no state shall deprive any person of life, liberty, or property without due process of law. And I'm sure you studied this doctrine, you probably never actually understood it. Incorporation, right? Remember this? The doctrine of incorporation says that there are certain liberties that are so important that we can't have a free society without them. Among these liberties are the first 8 amendments in the Bill of Rights. And because of that word liberty in the 14th Amendment, these liberties are extended to the states. So no longer is the First Amendment limited to Congress, but now the state's police power is limited by the 14th Amendment. The 14th Amendment radically changed the relationship between the state and the federal governments. So if I were to ask you before the 14th Amendment, what are the limits on the state's police power? That was correct. Commerce, treaties, foreign war. He was right. But the 14th Amendment changed the ballgame. And it changed it by placing a direct limitation on the state's police power. Because no longer can states infringe on free speech. Okay, everyone with me so far? Okay. But what's another way under the 14th Amendment that the state's police power is limited? It's not just Section 1. What else in the 14th Amendment limits the state's police power?
Section.
Say it louder. Section 5. What's Section 5? Right up here. Section 5 of the 14th Amendment. What's Section 5 say?
Congress shall have the power to enforce by appropriate legislation the provisions of this article.
What does that mean?
Section 5 gives them the power to enforce one.
Power to enforce what?
Section 1, which we just read.
And how does that work? What does that mean? What does it mean to enforce Section 1?
So that essentially means that Congress can enforce appropriate legislation that they're entitled to make where the states infringe on constitutional rights of their citizens.
Okay, good. So let's think about this, right? So Texas passes a law banning flag burning. I'll use this example because it actually happened. The case is called Texas versus Johnson. It was a 1987 case, right? Texas has a law that bans flag burning, and they prosecute some guy named Johnson for burning a flag. Okay? Let's say Johnson goes to jail, pleads guilty, doesn't really contest it, doesn't really care. There's a fine of a few dollars, doesn't feel like going to court for it. What happens to Texas law, Colin? If the guy just goes to jail, just pays his fine, doesn't do anything, does Texas's law stay in the books?
Yes.
Yeah. So we often think is the only way of limiting the police power is when people sue the government, right? He could have, Johnson, filed a lawsuit saying, hey, dismiss my conviction because, this is free speech. But what if Congress passed the the Flag Burning Protection Act of 2010 or whatever, right? And they said, any state that enacts a flag burning statute can be sued. It can be sued in federal court. So in the first case, I said, what happens if Johnson burns a flag and is arrested? Right? If you're arrested, you can obviously go to sue, and we can challenge your conviction. But what if the law says Congress passes a flag burning statute and says any state that passes a flag burning law can be sued in federal court for damages? What do you think about that statute, Zach?
From the reading, it seems that it would require the state's consent before it can be sued in federal court for civil damages.
And this is the issue which we're discussing today. So Zach, what happens if flag burning statute, right? You haven't prosecuted under it. Harris County Court down the block, you say, hey, I want to file an action saying that Texas violated the Constitution. I'm suing the state of Texas. What would the Texas court say to you?
I mean, the Texas court, obviously,
Say, would you even get merits?
no, I would say,
Why would you not get to the merits?
well,
But what are they going to say to you? What's the first thing a court must have before they do anything?
jurisdiction.
Jurisdiction. Is there a jurisdiction for you to sue the state of Texas in a Texas court?
No.
Why not? You said it a minute ago. You said it 30 seconds ago.
You can't sue them without their consent.
Yes. You cannot sue a state unless it consents to the suit.
Your state.
Get it. Hold on. We're getting there. Right? I'm just talking about Zach. He lives in Texas. He's suing Texas, right? Texas did not consent. So before you even file your complaint, the judge will say, I got no jurisdiction, dismissed. Right? But Eddie, what happens if Congress passes a statute saying, you know what? Texas messed up. They passed this evil flag burning law. We're going to give Zach the right to sue in federal court. We're not going to dismiss it. We will give jurisdiction to our courts to allow you to sue, to challenge this. Could Congress pass that statute? Would that be a constitutional law?
Could they?
Yeah.
You're saying could they?
Would that law be constitutional?
I think not.
How come?
I want to think that it's because of,
Can Texas waive, I'm sorry, can the United States Congress waive the sovereign immunity of Texas?
No, I mean, I didn't think so, no, I don't think so. No,
Diego, what do you think?
They can in cases that infringe on our 14th Amendment.
Yes.
They can operate.
And this is the key point, right? Generally speaking, a state has this notion of sovereign immunity. However, Congress has the power under Section 5 to intrude into that sovereign immunity, but only so far as to enforce the Constitution. So a classic example is the Voting Rights Act, right? The Voting Rights Act. Congress had evidence that various states were disenfranchising blacks, putting up poll taxes, literacy tests, you know what these are, right? Making it impossible for people to vote. The 15th Amendment says the right to vote cannot be denied on the basis of race. Congress enacted the Voting Rights Act. This was a very significant piece of legislation in that it intruded to state matters. It told certain states, hey, anytime you want to make any changes to your voting procedures, you need to go to a federal judge in Washington to get permission. What's called pre-clearance, right? If you want to move your polling station across the street, or you want to change the way your voting forms are printed, you need to get permission from the Department of Justice or a federal judge in Washington. Okay? On its face, putting aside the fact this is a voting law, this was a significant incursion to state sovereignty, right? This is telling states how they run their police power. This is managing at a very minute level how states operate. But the Supreme Court held that because these states were violating the 15th Amendment, because they were denying people the right to vote on the basis of their race, that this is a justified incursion into state sovereignty. Okay? Yes.
I'm confused with this, what you just say, and the, was that contradict with Amendment 11?
Oh,
11th Amendment?
that, let me ask you a question. Which came first in the Constitution, the 11th Amendment or the 14th Amendment?
I would say the 11th,
Which one came later?
14th.
So when you have two different laws,
Yes, yes.
when you have two different laws,
I get
which
it.
one trumps the early one or the later one?
The later one, yes.
So this is actually a really odd concept. I'm doing this a little out of order, so I'll go back. This is an odd concept of constitutional law. My thing finally turned on. It's an odd concept of constitutional law. The 14th Amendment modifies the 11th. The same way as the 14th Amendment nullified the 3/5 clause, right? Everyone's a person now. The 14th Amendment also modified the 11th Amendment. So let's go back to the 11th Amendment. I want to start with the 14th. But you have to recognize that the state's police power, sovereignty itself, is directly limited by the Constitution. So let's start as we often do with Article 3, right? Article 3, it says, the judicial power shall extend to all cases affecting ambassadors, other public ministers, consuls, and here's where our part gets important, cases where a state shall be a party. Okay? In these cases, the Supreme Court has original jurisdiction. What does that mean, Mike? What does it mean, that highlighted yellow part?
Where the states are party to a suit, the Supreme Court will actually have original jurisdiction.
So does that mean that the framers understood that people could sue the states? Does that mean that framers understood that the states could be sued in federal court, in the Supreme Court?
I believe so.
What do you think, Casey?
No.
What does it
I
say?
don't know why, I just remember from the case saying that they should,
Oh, you're right. But you have to give me a reason.
just, it couldn't have been anticipated.
Hugo, what do you think? That language itself, the language I highlighted, does that mean that the framers understood that the states could be sued in federal court?
Yes, they did.
How come? Why do you say that? Just the text, all we're going on.
Because other states could violate someone else's rights from some other state. They never conceived the idea.
What's the remedy when a state violates someone's rights? I know today we think the answer is court, but historically, what was the remedy when a state violated a person's rights? This isn't a jarring concept for you, but it's true. Historically, anyone? Not nothing. What happens when the state did something wrong? Anyone? The political process? Oh, see, all you are lawyers, and your first instinct is to sue over everything. But when the government messes up, you can throw them out of office. I love law students. Your first instinct is sue. No. And see, the fact that you didn't even think about this, I discussed this last week, but you know, you saw my testimony last week to Congress where I said at the very end, this is a problem for Congress to fix, not the courts, right? And so what did the Congress do? They gave in, they caved. And what did the Speaker of the House say? He said, our courts are our best chance for success. Wrong. Wrong, 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 wrong. The best chance for success is politics, but when politicians are craven and they don't fight for things, they give up their own power. So I appreciate, yes, Hugo, you're right. The remedy would be political process. But the mere fact that framers put this language in doesn't necessarily mean that the states could be sued. Does it say here, Hugo, whether the states are plaintiffs or the defendants?
No.
Ah. So maybe they thought the states would be doing the suing. Maybe one state wanted to sue another state over a boundary. So the text itself actually isn't entirely clear that the state was a defendant. Maybe the state was a plaintiff. It just says party, right? We don't know. So we go down. So immediately after the Constitution was ratified, we have our old favorite, the good old Judiciary Act of 1789. This was the statute at issue in Marbury, which we studied, very first week of ConLaw. And it says, the Supreme Court shall have exclusive jurisdiction for cases with, quote, state and citizens of another state. Jason, what's that saying? Does that suggest that the states can be the defendant? Does it have to be the states the defendant?
It doesn't have to be.
What could it be?
It could be where the state is the plaintiff.
Yeah. Why is this not a case where the plaintiff is the state and the state sues an individual? It's hard to imagine where the states are suing individuals, right? If you're a state and you want to go after someone, you're probably going to arrest them, throw them in court. You're not going to be suing them for damages, but it's, yes.
I mean, yeah, in 1789, where you don't have a massive, administrative bureaucracy that uses regulatory power, the state might conceivably be more inclined to sue to get.
They didn't have,
boundary
tarring and feathering was very effective back then, right? But yeah, your point's well taken, but as it's written, it's not clear, okay? And this brings us now to our first case, 1793, called Chisholm v. Georgia. And this was probably the first big constitutional law case before the Supreme Court. This was before Marbury by like 8 years, okay? And at one point I want to stress to you, this is 1793. We are 4 years after the ratification of the Constitution, 2 years after the Bill of Rights. And they're already arguing over the meaning of a provision where the ink had barely dried. So our enterprise is trying to figure out what was meant 200 years ago. They couldn't even agree 4 years earlier, 4 years later. Okay? So Chris, what happened in Chisholm? What were the facts there? Just some simple facts.
Honestly, I didn't read that case, but I didn't think it was a sign.
Yeah,
that case wasn't a sign.
All around it is like, about it, not that.
Did I not assign Chisholm?
No, the first one was.
Okay, my bad. My mistake. I thought I assigned it. Okay.
You did.
Did I?
I think you did. A citizen of another state suing Georgia or something.
I thought I did. Hold on. I'm
Yes or no?
It's not on the website.
it's in my notes as assigned. Well, in any event, yeah, no, it's there. 557, 558, 1262.
It's
Starts on 5.
Yeah, but there's a note about it.
Yeah, that's it.
So you didn't read the note. Okay, well, okay, so I did assign it. Okay. I'm not crazy. Yeah, okay, so there's a note about it. Yes. So even the notes in the cases, you have to read the little notes. Those exist for a reason. Okay? Anyway. So Hansi, Louisiana, what were the facts in that one?
Citizen of another state suing Georgia about the Boerne.
Yeah.
Yeah.
So what happened was you had a guy, I think he's from South Carolina, named Chisholm. And he was owed some money by the state of Georgia.
Yes.
And these were over bond debts. Basically, from the Revolutionary War, there were various bonds given. Okay? And Georgia didn't pay up. This was very common that the states were just reneging on their debt. This was a recurring theme. So what did Mr. Chisholm do? He's like, oh, wait a minute, look. I got the Judiciary Act of 1789. I can't go to a Georgia court to sue because a Georgia court will throw me out. There is no jurisdiction. Okay? But I have this Judiciary Act of 1789. Let me go to the Supreme Court in its original jurisdiction, same place Marbury went, and let me sue the state of Georgia to collect my money. Okay? Now, interestingly, this case had a unique feature. John Marshall did a lot of very good things. One of the best things John Marshall did was to introduce the idea of majority opinion. This may seem very common to you, but in the 1800s, there were no majority opinions. Each justice would write his own opinion, and then it'd be up to us to figure out what the heck the holding of the case is. You think figuring out a holding's hard now? You would have, in this case, 5 different opinions called seriatim, S-E-R-I-A-T-A-M, and they'd each be listed one after another. And you have to try and figure out, okay, what's the most narrow rule from these 5 opinions? It'll drive you crazy, okay? So in this case, the vote was 4-1. Justice Iredell, I mean, he wasn't actually dissenting because there was some majority opinion, but it was, it was effective a dissent. And Justice Iredell said, listen, since the beginning of time, the king could do no wrong. The crown could not be sued. This was a maxim of English law, right? If the king did something wrong to you, right, Chris, if the king ever did something wrong to you, what was your remedy? I'm sorry? Throw some tea in the harbor. Basically, yes. You did not have a remedy. I mean, your remedy was a political process. You could file what's called a petition of right and hope the king dispenses some grace to you, some equity, but you had no legal remedy. The king could not be sued. So Justice Iredell says like this: before 1776, the king was a sovereign. He was the ruler. Okay. When the states declared independence, Chris, what happened to that sovereignty? The states had it, right? So at independence, the Declaration of Independence, the states assumed the sovereignty. The states assumed that power. But then, PJ, what happened with the Constitution? What happened to that sovereignty? Not to the feds. What is the basis of sovereignty of our Constitution? The basis. First three words. We the people. The magical idea of our Constitution, unlike the Articles of Confederation, this was not a league of sovereign states. This was a group of people. We the people, every one. So effectively what happened is that upon independence, the states absorbed the sovereignty of the king. But when the Constitution was ratified, it wasn't ratified by the states. It wasn't we the people of New York and New Jersey. It was we the people of the United States, right? So this idea of sovereignty, of sovereign immunity, is a tricky one because it requires us to think of our states the same way we think of the King of England, when we had just thrown some tea in the harbor and blew up a lot of stuff to reject that line of thinking, right? So the dissent by Justice Iredell says, wait a minute, this is not right. States are like the king, right? But the other four opinions, what I guess you can call the majority rule in that case, by Chief Justice John Jay and others, like, wait a minute, we just fought a war over this, right? The sovereignty of this country is not in the states, but in the people. The states do not have the right to ignore lawsuits. If the Constitution says the judicial power extends to suing the state, then the states consented to that. Let me say that one more time. Who ratified the Constitution? The people of the states. And what do they agree to when they ratified? That. They agreed to a provision which says states can be a party in litigation. Right? So even if Justice Iredell was correct, that maybe before the Constitution the states were sovereigns, after the Constitution that position becomes very difficult to defend because of the nature of we the people. Everyone get that? So this was the point, this was effectively the majority rule in Chisholm. But as you read in the note, after Chisholm was decided, there was a massive backlash. A massive backlash, right? Angelina, what was the nature of this backlash? What was the nature of the backlash after Chisholm v. Georgia and this decision?
The limits of Congress?
No, what happened? What did the people do after Chisholm v. Georgia? What was the reaction?
I don't remember.
Lacey? It was in the notes. You have to read the notes. Don't have it?
People were surprised, and some people were surprised that the state can be sued.
Yeah, Lauren?
The 11th Amendment.
The 11th Amendment. You're both right. You're both right. People were shocked at this ruling. They thought, how is it possible that a state, Georgia, can be sued by some foreigner from South Carolina, right? It's easy for us to sit here today and say, oh, of course, we the people, sovereigns for everyone. But a lot of these people are still acculturated thinking in the colonial mindset that the state was sovereign like the king. Maybe they didn't even get the Constitution. I don't know. Maybe we don't get it. Who knows? But there was a massive backlash, which led almost immediately to a constitutional amendment. This was only a few years after the Bill of Rights was ratified, right? This was the first amendment after the Bill of Rights was ratified. And this was occasioned by Chisholm. So I want you to compare the language. I'll put them on the screen at the same time. The one above it is a Judiciary Act of 1789, and then the 11th Amendment's below it, okay? Kelsey, just based on the text, what was the 11th Amendment trying to do? Only look at the text, don't look at history or anything else.
I mean, it's almost like they were trying to protect the states from.
What were they trying to reverse? What were they trying to negate?
Chisholm happening.
Specifically, look at the language. Lauren?
Would it be to make like a citizen of another state sue the state that they're not in?
Good. What the language was trying to do, and Kelsey, you said it, but Lauren put a finer point on it, was they were trying to negate Chisholm as authorized by the Judiciary Act of 1789. What does it say? The judicial power, that means jurisdiction, right? Jurisdiction does not extend to any case that's prosecuted against the state. So here, this isn't saying whether a state's a party or not. It's saying against the state. That means the state's a defendant. So you can't have any case where the state's a defendant where the plaintiff is what, Kelsey? Who can't the plaintiff be?
Another state.
A citizen of another state, right? This is the key. It says simply, you can't have a case where a defendant, state, plaintiff, citizen from another state. So you can't have a situation where a citizen of South Carolina can sue the state of Georgia in federal court. Okay? That's all it says. That's all the 11th Amendment says. There's nothing more than that. All right? So Jordan, what happens if, say, a citizen of Louisiana tries to sue Louisiana in federal court under this amendment?
It doesn't apply, right?
Under this amendment, can Congress give jurisdiction to a suit where a citizen of Louisiana sues the state of Louisiana?
I think so.
Why?
They're from Louisiana?
Does this say anything about a citizen suing his own state? No. Okay. So this is going to become one of the biggest wrinkles in constitutional law. I just spent all this time talking about a principle of sovereign immunity, right? Sovereign immunity. Colin, if the framers of this amendment wanted to instill this principle of sovereign immunity to the Constitution, what would they have written? How would they have embodied this idea that the state can never be sued? What would they have written? How could they have reframed this to make it clear that under sovereign immunity, the state can never be sued? What could they have written?
They would have added the language that the citizens couldn't sue their own state as well.
Yes, 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 right. Yeah, exactly. Any state, exactly. So if I can make, right, if I can make an alteration here, right? I've done the trick, right? State can't be sued by a citizen of any state, period, done. Clean, right? Would there have been any ambiguity there, Colin, about what the amendment meant?
If they would have said any state.
Yeah. Or, even better, by citizens, period. Period. Done. End of sentence. By citizens, period. Or better, by anyone. How about that? Is that clear? Crystal clear, right? But Congress didn't use those words. They said something very specific. They said by citizens of another state. So this leaves us with something of an anomaly, right? Where in federal court, I could sue Texas, but I can't sue Louisiana. Because I live in Texas. I'm officially a citizen of Texas now. I think I got my Texas green card came in the mail recently. I'm got lost in the mail in Staten Island, but finally got here. So you have to really know where to find them. You have to get the right chili to get it. So they had them at the rodeo, actually. You have to pick it up at the livestock show. So Congress did not enact this amendment, though. The people did not ratify this. That brings us to Hans v. Louisiana, the case which I think pretty sure was in the reading as well. This case involved also a state not paying its debt. You're sensing a pattern here, right? States are very good at not paying debts. And I should stress the political process is not very good here because who wants to force a state to pay money to someone? It's better when the state just has money because they don't have to raise taxes that way. So in Louisiana, this guy Hans, he was a citizen of Louisiana, sued for the amount of $87,000 in 1890. And I did the math, it's about $2.2 million in present day value. So this was a significant amount of money Louisiana owed him. Louisiana changed their constitution, said, guess what? We're not paying any more debt anymore. Be gone, debt, right? So Mr. Hans went to federal court in Louisiana, New Orleans, filed a suit. Right? What was I up to? Zach, what happens there?
Basically, the rule we get from this is a citizen of the United of a state cannot sue that state in federal court if there's a lack of jurisdiction.
Okay, how do we get that, or how does the court get that from the 11th Amendment? What's the reasoning there?
I know they mentioned, look at it contextually, that this wasn't something that was imaginable at the time, that an individual suing their own state. They reference Federalist 81, they kind of use that as the originalist support for how they kind of interpreted.
Right. So what's really interesting is that the majority opinion in Hans v. Louisiana cites not the majority in Chisholm, they cite Iredell. They cite Iredell for the proposition that the states are independent sovereigns and they can't be sued. Even though we just spent all this time discussing why that wasn't an accurate summary of American history. But the point you have to understand is that people don't agree on this. And the Supreme Court, a majority of them, said, you know what? The states are sovereign. Even though the text of the Constitution is pretty clear of what should happen. They said that the judicial power shall not extend to a suit against anyone, right? Any state, by anyone, all right? This holding was probably wrong. And, I don't say that lightly, but the Supreme Court probably botched this up. Doesn't matter because this is now 100-year-old case law and it's firmly embedded in our jurisprudence, firmly embedded. There's not even a question about this, okay? So as it said, Eddie?
I really had problems with this as well.
Good.
Because
it means you're thinking the right way if you have problems.
The language of the document
So clear.
is clear, and yet they moved to, they didn't seem to even argue it by implication. They just argued it in a much more nebulous fashion to me. It's like, I could have even accepted an argument by implication if, in order to get them where they wanted to be, but they didn't even do that.
What would the implication be? What would that argument look like?
I think it'd be a weak argument, but I think
You're right.
the text of the document plainly
Speaks
says
for
what it
itself,
says.
right?
But I think it'd be a weak argument, but at least that would be an improvement over simply saying it's inconceivable.
Anomalous, yeah. Right, so I mean, the opinion basically says, look, this could not have possibly been the design of the framers, right, of the 11th Amendment, to say, oh yeah, you could sue your own state, but not a foreign state, right? And I think the reason, I'll give a charitable defense of it, right? The reason goes like this. If you're a citizen of Louisiana, your remedy is a political process, right? You are a citizen of that state. You can vote there. So if they do something wrong, you can throw the bums out of office. But if you're a resident of a foreign state, you can't vote there. So you have even less access. So it really should be backwards, right? Citizens of foreign states should be able to sue, and not citizens of the domestic state, right? I would have actually even accepted that argument. I don't think it's good. But the court adopted this broad notion of sovereign immunity. Okay? So I didn't get that much. Yeah, Hugo?
If we were to fast forward and we had the 14th Amendment, could he have sued because they were trying to remove his property, and that law was discriminating people like him that had the bonds with the state?
Okay. You're conflating two things, so I'm glad you did that. Jurisdiction is separate from your cause of action. Here it's undisputed that Louisiana violated the Contracts Clause, right? They didn't pay him his money. But in order to sue for that cause of action, you need jurisdiction. This is eerie, right? I'm sure you buried that in your minds, right? But at this point, there is still federal common law, and they can create federal common law. But a prerequisite of Erie is you need jurisdiction. And the only way you get jurisdiction is by a judiciary act, which is subject to the 11th Amendment. So if you can't sue Louisiana for breaching contract, too bad. You're not going to get your money back, even if they violate the Constitution.
Is the consent by the state, is the consent to be, for the case to be heard in a federal court, or is it consent to be sued at all?
In state court. So here's how it works, right? Could Louisiana pass a statute saying, you know what, we will allow you to sue in our state court for a breach of contract of more than $100,000? Could Louisiana have done that? Of course they can. States can always waive their own sovereign immunity. Right. I mean, there's certain circumstances where you can sue the state of Texas, or certain, intentional torts, for example, right? If a state official engages in some sort of intentional tort, I'm pretty sure you can sue them. If it's some sort of negligence, you may never be able to, right? So even states in various aspects, they waive their immunity in their own courts. But states almost never will waive their immunity to be sued in a federal court. So that's a foreign court. They have no control over it, right? Because in state court, they can set amount of controversy. They can set rules of evidence and procedure. They can do things very clearly. Okay, everyone with me so far? So this is only the 11th Amendment. We haven't gone to the 14th yet. Now let's talk about the 14th. And I said this at the start of class. But under Section 5 of the 14th Amendment, can Congress waive a state's sovereign immunity? This is the question for the other two cases we have assigned for today. What if Congress decides that a state is engaging in unconstitutional activity? Can they give jurisdiction to their federal courts to allow people to sue? I mean, if you think about it, the Department of Justice, right? They have the power to go and sue a state that's breaking the law. They can do that. They can file a suit. But they have limited resources. What if DOJ wants to deputize private citizens who have their rights violated? Let them go to court. Let them get attorney fees. Let them fight for it. Okay? That's the nature of the next few cases, where Congress held in various cases that the Section 5 powers allows you to waive state sovereign immunity. Or the fancy word is abrogate, A-B-R-O-G-A-T-E. In limited cases, Congress can abrogate or waive a state's sovereign immunity. Okay? Oh, before I get too far, one point I want to mention. Has anyone heard of Ex parte Young? Anyone hear about this case? Okay. What's Ex parte Young? What did you say? I'm sorry?
So I just heard about it.
You heard about it. Anyone know what Ex parte Young is?
Citizen could sue a state official to prevent that official from carrying out a state policy that was unconstitutional. constitutional?
Right. Okay. So the general idea is that a citizen can't sue a state. But 20 years after Hans v. Louisiana, the Supreme Court created an exception to that called Ex parte Young. And while you can't sue a state, you can sue a state official. You're saying, oh, Josh, what's the difference? Well, I'll explain the difference, right? You can sue a state official who is about to violate your constitutional rights. So say some state official is about to enforce some law that violates the 14th Amendment, right? He's about to, enforce a requirement to segregate schools, right? Pick an easy one, right? You couldn't sue the state of Texas, but you can sue the commissioner of schools, the secretary of education, whatever the title may be. But one limitation, though, is that when you sue, you can't sue for damages. You can only sue for injunctive relief. So you can get an injunction to stop the secretary of education from segregating the schools, right? That would be permissible. But you cannot sue for damages for having the segregated schools. So this is a significant limitation on Hans v. Louisiana 11th Amendment, but only gets you injunctive relief. Okay? Everyone with me so far? We got that? Take federal courts. I really encourage you to take it. It's a good class that not enough people take, and you learn a lot about federal court litigation. You'll spend an entire week on Ex parte Young. I summarize in 3 sentences, but it's a very complicated doctrine. Okay? But take federal courts. You'll be better for it. Okay, so yes, sir.
Is that, I'm curious as to, this is a terrible way to ask the question, but is that a good thing?
Is what a good thing?
Ex parte Young's allowing you to sue for injunctive purposes to stop a state official from infringing upon your.
Do you think it's a good thing?
I knew you were going to do that.
We're now in class, what, 8?
Well, I think yes, it can be a good thing, but then I guess it can cut the other way as well. But no.
Why would it be a bad thing? What are the reasons?
No,
What's the downside to Ex parte Young?
I'm going to back up and say I'm not sure that there is. There's got to be a downside.
Oh, there's always a downside.
There's always a
What's the downside there? It's infringing on state autonomy, right? You're getting a federal court to tell a state official what to do. He hasn't even done it yet.
So if he hasn't done it yet.
So the flip side is wait for him to do it, and then when it actually impacts you, you can sue. Because if you're arrested for entering say it's a segregated rail car, right? And the Secretary of Transportation is also segregating all the rail cars. You enter it, you get arrested, you're indicted, you can challenge the indictment in court, right? The difference here is it's a pre-enforcement challenge. So you're actually telling a state official what to do before it's actually being done. So that's the defense. I'm not making that argument. That would be the defense.
So could we expect the lawsuits against an Alabama representative if they fail to enforce?
Okay, so this issue, I think I mentioned this in class before. It's really complicated. So the issue in Alabama isn't what you've read in the newspaper. It's actually really complicated. So here's the condensed version. Under Alabama law, probate judges are a member of the judicial branch, but they have certain administrative duties, which is handing out licenses. Okay. When these same-sex marriage lawsuits were filed in Alabama, the couple sued the attorney general, who's the head of the executive branch of the state. They did not sue the probate judges. Okay. Why does this matter? Because the injunction given by the judge in Alabama could only bind the people who are parties to that case. The only people who are parties to the case were the attorney general, who had no authority to issue marriage licenses. None. Okay? So as insane as it sounds, the probate judges are not bound by that injunction, but I'll caveat that. State officials need to act in a constitutional manner, right? At this point, they should have a pretty good indication that they're going to be required to give out these licenses. It's almost a done deal at this point. But they have a conflicting duty to uphold Alabama law to take an oath to that office. And under Alabama law, the same-sex marriage ban is still good law. A federal district court only has jurisdiction in that part of the state, right? States are not required to acknowledge it. And the Alabama Supreme Court upheld the law. So under Alabama law, the probate judges are actually acting correctly by not handing out these licenses. The only remedy at this point, short of a Supreme Court decision, would be to sue every single probate judge in the country and get a judgment against them, or a class action, which are hard to certify. So the Alabama issue is not how it's being portrayed in the media. It's kind of obnoxious, but they're not bound because they weren't sued. It's happened also in Florida as well, but the Florida judges just gave in. But it's Alabama. Anyway. But yes, when a state official under color state law violates someone's well-established federal rights, they're going to hit with a judgment and pay attorney's fees. It's expensive. There's going to be so many attorney's fees paid in this case. So even if these probate judges are not obligated to have these licenses, if they're sued under 1983, they will have to pay fees, and that's going to be really expensive. And they will be sued. Lawyers like getting paid. That's one thing lawyers are good at, trying to find money. Okay, any questions about that? Move on. All right, let's talk about the next cases. Anyone know Boerne, Texas? Anyone ever been there?
Yes.
Do you know where this church is?
Yes.
Really? Have you been there?
I've been by it.
So this is St. Peter the Apostle Church in Boerne, Texas. It's looks beautiful to me. And the facts of the case were like this. The church was quite old, and they had an influx of parishioners, and it's a good thing. And they decided that they needed to expand the church. They had people standing during Mass. They didn't have room for everyone. So the Archbishop of San Antonio authorized the church to expand. And they actually wanted to knock down walls and make it bigger. I'll show you some picture of the inside. So it's a beautiful church, very old style. But you can see there are not many seats. Okay, and there's an exterior shot. Okay, so what happened? They applied to the city of Boerne for a permit to expand their church. The city of Boerne said, "Oh, wait a minute! This church is so beautiful. You guys can't break down the walls. We're going to declare you a historical preservation site. And as a historical preservation site, you can't build. You can't expand the walls." Okay? The church is like, "What are you talking about, right? We can't serve our flock. We can't service the members of our church because we have nowhere for them to sit. You're violating our religious liberties." Okay? In any other context, in Texas or Boerne, wherever, not Houston, if a city zoning board said, "You can't build this," and the people said, "Well, we really want to," and the city said, "Too bad," would there be any way around it? No. But this was unique. It was a church, and the church claimed its religious liberties were violated. Right? So where was that? I forgot. Jordan. So Jordan, let me ask you this question. Could the church, Flores, with the Archbishop, could Flores have sued under the First Amendment, claiming that the denial of his building permit violated his religious liberties? Yeah, under the First Amendment. Forget the city. In general, was there a First Amendment violation by not letting him build? Forget about suing.
I don't think so, but I can definitely see how it could be.
I think, Colin, could he have sued under the First Amendment here?
Well, for the building part or for the religious part?
All they did was they denied a permit. That's all they did.
I would say no, but when you bring in the religious.
So we have this. Hugo, what do you think?
I don't think that, I don't see how having a bigger church or having a smaller church infringes upon his religious practices. I mean, they can have congregation outside, they can do it in a different place. Building isn't necessarily directly related to.
So what's the relevant test here? Right, Zach, what's the relevant First Amendment case here about whether the rights were complied with? What's the case they discuss that changed everything? Eddie, you got it?
Was it the peyote case?
Peyote case. What happened to the peyote case?
I think they were Native Americans. They were going to, I think they were gotten fired from their government jobs or their state employment jobs. They're using peyote and could not collect their unemployment benefits.
Yeah, actually, the facts are even better than that. So the guy name was Joseph Smith, not a different Joseph Smith. He was a Native American, okay? And part of his religious sacrament was to ingest peyote. Everyone know what this is? It's like this hallucinogenic cactus. It makes you go trippy, right? So it's part of a lot of Native American religious rituals. The only problem was he was a drug counselor. He worked for the state to help people with drug addictions, and here he was ingesting peyote. So he took for a drug test, and unsurprisingly, he flunked. And then he was fired. And then he tried to collect, denies him, saying, "Wait a minute, dude, you were fired for doing drugs. You don't get unemployment. You know, it's not. You weren't unfortunately laid off, right?" So he sued and said that this policy burdens my religion. In a 5-4 decision by Justice Scalia, very famous, the court said, "Sorry, Joe, you don't go. This law on its face is neutral, right? This law on its face is neutral. It says no one can do drugs. If you do drugs and you're terminated, you don't get your unemployment benefits." Even though this law does impose a burden on religion, because it's saying, listen, you can smoke or keep your job. You can't do both, or ingest, whatever you do with peyote, right? So it puts them in a tough choice. But the Supreme Court said, listen, this is a neutral law. Okay? Distinguish this case with another case you may have studied called the City of Hialeah versus Babalu Lukumi. This involves Santeria. Everyone know what Santeria is? It's this Afro-Caribbean faith. And part of the religious sacrament is that they do sacrifice of chickens. It's a bloody thing where they slice the chicken's neck and, there's blood everywhere. Google it, right? But that's part of their religion. So the city of Hialeah, Florida, near Miami, passed a law basically prohibiting the slaughtering of chickens. Now, if you look at the statute on its face, neutral, right? It says nothing about Santeria. But the only people in the city who killed the chicken in that manner were the Santeria. So the Supreme Court said, even though on its face this law seems neutral, it really isn't, because you're targeting this one specific faith that you don't like. Unconstitutional. But so long as a practice was neutral, even if it burdened religion, it was fine. I want to see this. So Mike, this zoning law in San Antonio, in this case, did it burden the religious beliefs of the church?
I think so.
Yes, Archbishop Flores, what do you think he said?
He probably said yes.
Archbishop Flores said yes, it burdens religion. Was this law neutral? Was there anything in the zoning law that singled out religion?
No.
Of course not, right? They denied it because they thought it was a pretty building, right?
We're just limiting the space on which you can practice.
Right. So here we have a situation, right? The law on its face is neutral, but it does have a burden on religion. So under the peyote case, would Archbishop Flores have a case? Would he win under the peyote case?
No.
No, he wouldn't. But we have a new law, the Religious Freedom Restoration Act. If you want to be cool, RFRA, as the cool people call it. Okay? RFRA was passed in 1993 in response to Smith. The same way that Chisholm v. Georgia spawned the 11th Amendment, RFRA didn't result in a constitutional amendment, although they maybe should have. It resulted in a statute. And the purpose of RFRA, and I'll grossly overstate it, was to restore, restoration, right? Restore how the First Amendment operated before Smith, before the peyote case. So they said, listen, we want to bring back the way the First Amendment was before. Everyone see that? Casey, let me ask you this question. Who gets to decide what constitutional rights mean? Congress or the courts? Who gets to decide what free exercise means in the Constitution? What happens if the courts give a very narrow understanding of free exercise and Congress says, oh man, that's too narrow, let's give more rights?
And Congress just changes the law.
No, not the law. We're talking about the First Amendment here. Who gets to decide how broad First Amendment protections are? Congress or the courts? What?
Well, they're the ones making the law, so I guess if
No, but they're not making law. My question is very precise. Who gets to decide the scope of First Amendment rights? So I said, before the Peyote case, right, the First Amendment rights were really broad, and they were narrowed by the 5-4 decision. What if Congress disagrees? What if they think Scalia messed up? Nino messed it up, right? Who gets to decide what constitutional rights mean? Where do we get that from? Where do we get that that the courts decide what rights mean? Where is that in the Constitution?
Section 5 is the power to enforce their legislation.
No, that's for Congress. Where do we get from the Constitution, Casey, that it's the courts who decide what rights mean?
It's like the separation, just the whole idea of it.
Hugo, what do you think? Where do we get this idea that the courts are the ones who decide what rights mean? Why can't Congress decide what the Constitution means?
Is it, Congress has, I guess they have the enumerated rights to only do so much, and everything else is, I guess, at the mercy of interpretation. And
Are these unelected judges the sole people who decide what rights mean? Why can't Congress decide what rights mean? Why can't Congress disagree with the courts on what the Constitution means? Why do the courts have a monopoly on constitutional interpretation?
Because Congress wanted to in the first place, they should make them very specific. And
What do you think, Jason?
Well, I think Congress, because Congress the judiciary has no power to actually amend the Constitution. So Congress has that power. Therefore, the judiciary having the ability to interpret that gives them kind of a balance of power.
What do you think, Chris?
Yeah, if Congress is able to do both, there wouldn't necessarily be a need for judiciary.
Good, interesting. What do you think, PJ?
yeah, I agree with that.
Can you give some more? What's the one case? If I were to ask you, what's the case that gives us the idea that the courts decide what the Constitution means? What would you say? Marbury. So really, this idea that the courts are the final arbiters of the Constitution comes from the courts. Marshall gave the power to himself. That's nowhere in the Constitution. There's nothing, we discussed this already, right? There's nothing clearly in the Constitution saying that. But here, the Supreme Court proved it. Because what happened? With RFRA, Congress tried to expand what the First Amendment means. They tried to say, you know what, Scalia, you're wrong. We are going to decide what the First Amendment means. We're going to expand the protections of free exercise. What did the Supreme Court say to that? Efforts by Congress to define what First Amendment rights mean. How did Justice Kennedy or Moses, right? How did he, or Hammurabi, if you will, how did he respond to this?
No way, Jose.
No way, Jose. Exactly. I think that was actually more articulate the way you put it. But yeah, very well said, my friend. No way, Jose. Exactly. He's like, get off my lawn, basically. This is for us to decide. The court decides what rights mean, not Congress. Why that? Why is it no way, Jose? Why did Kennedy say that the courts have this job alone?
Well, because of first of the judicial review from Marbury case, right, and it's all precedent before whenever it comes to the Constitution, it's always the court who review and who decide what Constitution will mean.
But beyond that, let me ask you the follow-up question. If Congress can decide what rights means by passing laws, is there any difference between statutes and the Constitution at that point?
there will be no check and balance, like what Mike said earlier, that if they pass the law, they are the same one who say, yeah, that's the right one.
That's right. So this point, I think Kenny makes a little bit of the no way Jose, right? This point is, if we put legislation and the Constitution at the same level, and Congress by passing a statute can redefine legislation, our Constitution loses its meaning. Because any Congress make it mean this or mean that and fluctuate, right? Our Constitution is supposed to have a fixed meaning. Angelina, the court's good at guarding the fixed meaning of the Constitution. What happened here? What happened in Smith?
So Smith was the peyote one.
Were they consistent in their interpretation of the Constitution there?
Well, my opinion.
Well, by their own opinion, did they uphold the previous precedents for in Smith?
Of Bernie.
No, of the previous previous precedents before Smith. What did Scalia do in Smith? You got it?
Neutral in Smith, but that was, I think before that, they said there had to be a compelling.
So the court changed directions, right? So is there much of a difference between Congress changing its direction through statutes and the court changing its direction through opinions?
Yes.
What's the difference?
I would say that, I guess like using the Obamacare, like they passed a statute and whether the courts decided whether they would enforce it. So the courts changing the way their opinions changes how we like. Whether
Is there any difference between the court changing its mind and Congress changing its mind?
it's more limited, yeah.
Why is it more limited?
Because it has to be challenged, it has to.
Ah. So yeah, so I think you're on the right track, right? There is institutional something in courts called stare decisis, right? Where generally courts stand by precedent. They're not going to start overturning stuff. Congress will change your mind every 5 seconds, right? Every 2 years, every new Congress. The courts are supposed to be unaccountable for a reason, because they're supposed to be independent. And they're supposed to consist with tradition and precedent. Whether it actually happens or not, it's a different story. In the peyote case, Scalia said, no, I'm reversing 30 years of precedent. That's all wrong. Bunch of hippies smoking peyote, not going to happen, right? By the way, it's a funny story. RFRA, which today you probably know most from Hobby Lobby, which is a law that gives, that was afforded the Hobby Lobby Corporation the power not to give certain forms of emergency contraceptives to employees.
It came from peyote.
Yes. So the very law which is now being used by these Christian corporations was invented by Chuck Schumer and Ted Kennedy to give minority religions like Indians the right to smoke peyote.
Because it requires
Not strict scrutiny, but something like that. So it's a funny reversal of history where law meant to protect minority religions like peyote smokers and Santeria's chicken slaughters, right? Is now being used to shield corporations providing birth control to their employees. It's funny how law of unintended consequences comes back to bite people. Anyway, so it's a funny hit note. But the point was still, could, in this case, Congress allow Bernie to be sued? So we talked about the substance of the law, right? What does the First Amendment mean? But the more essential question is, Bernie never waived its consent to be sued. Texas never waived its consent to allow Bernie to be sued, right? Kelsey, could Congress waive Bernie's sovereign immunity? Could they do that?
I don't think so.
No. That was the holding of the case. No, Jordan, could Congress waive the sovereign immunity of Bernie and allow it to be sued in federal court? No, the holding case where they couldn't. I just said that. Colin, why could Congress not waive the sovereign immunity of Bernie? What was the test that the court had?
Because it wasn't, you mean a strict scrutiny test about their religion?
No. What was the test for waiving a sovereign immunity? What's that test called?
Congruence and proportionality.
Say it louder.
Congruence and proportionality.
What does that mean?
So they said that there must be a congruence and proportionality between the injury sought to remedy or prevent and the means achieved to do so, and it didn't meet the test.
Okay, so the court invents this test called congruence and proportionality. What does this test say? The powers under Section 5 are what are called remedial. What does it mean, remedial? It can't create new substantive rights, such as redefining the First Amendment. It can only address existing violations of the Constitution. So, for example, I'll go back to the flag burning example I gave at the beginning of class. If Congress passes a law, the Flag Burning Act of 2012, right, that says if anyone arrests you for burning a flag, you can sue them for damages in federal court, right? So we have a problem. The problem is some guys are arresting you for burning a flag, which is constitutionally protected activity. And we have a solution. You can sue a person for that specific transgression. You see there's a very close fit between the two. There's a close fit between the problem of the flag burning arrest and the solution of suing that police officer. You see, it's a very tight fit. So even though Congress is intruding into state affairs by allowing you to sue a state official, right? That's intruding in state police power. That would probably be permissible because it's a very close fit. Here, okay, what's the problem? And I think Mike alluded to this before. They're denying a building permit on a historical zone, okay? That's kind of a vague problem. But what's the solution? You can sue the city for damages. You can basically sue to have the city's zoning code set aside, right? They don't have this fit, this connection, what the court calls a congruence and proportionality. There has to be this connection between the problem and the solution to be had. So what the court says here is putting aside the First Amendment issue, right? This statute is so off the mark. It's such a wide-ranging, buckshot approach that it cannot be allowed. Eddie? No?
I understand this, I guess. I thought of it, congruence and proportionality. But I'm not, I guess I'm confused on what you just said they said.
Mm-hmm.
Maybe I misunderstood.
So the idea is the 14th Amendment's a remedy, right? It gives Congress the power to remedy problems. So you first say, what's the problem? Okay, so what was the problem with RFRA? Why did Congress enact the statute?
To affirm religious liberty.
Specifically, laws of general applicability, neutral laws, for example, peyote, right? This was meant to go after neutral laws and impact your religious liberty, right? So it's a fairly broad problem. It's not like flag burning, something specific. It's a fairly broad problem, right? What was the solution they adopted to fix that problem?
This is why I shouldn't have mentioned it.
What did Congress, what's the remedy under RFRA? What happens if the state denies a building permit to the Archbishop? What was his remedy?
My understanding was that while it wasn't an infringement upon their religious liberty,
That's
they
right.
were trying to
Just stay with me, okay? What was the remedy for Archbishop Flores? How did this case get to the Supreme Court?
He wanted.
What did he do? How did he get to federal court? It's an easy answer. You're thinking way too hard. What was the remedy that Congress afforded the Archbishop when he said his religious liberties were violated?
To sue.
Where?
In federal court.
And to sue whom?
And to sue the city.
The city. Had the city waived its sovereign immunity?
No.
So how was he able to sue the city? Who waived the sovereign immunity?
The federal
Congress.
Federal government.
Through Section 5, this is the key point, right? Through Section 5, Congress purported to waive the sovereign immunity for the city.
So you're saying the issue was that Congress was waiving the city's rights for the city,
Yes.
and that's questionable. as to
Why?
they can do that.
Why would Congress be able to waive a city's sovereign immunity? When would it be appropriate to do so?
Well, if it was a violation
Of?
some fundamental right, some constitutional right.
Yes. So if, that's why I keep using the flag burning example, right? Because that's an easy one. If the city of Boerne had passed a law banning flag burning, Congress could authorize a suit against people who want to arrest you for flag burning. Right. Look, they shall have the power to enforce the provisions of this article. As Angelina said a few minutes ago, that includes the incorporated rights, the Bill of Rights. So if a state violates the Bill of Rights, Congress can pass a law to let you sue them for it. That one of the rare cases where Congress can waive your sovereign immunity of a state is when the state's violating constitutional rights. Does that make sense?
Yes, yes.
But the question is, how close is the violation of the constitutional rights and the lawsuit, right? Is there any kind of fit? Because here it's very vague. They're saying anything that violates your rights, you can go to federal court and sue, no matter how trivial it is. The end of the day was the court said Congress could not waive the sovereign immunity of the city of Boerne because there was not congruence and proportionality, because there wasn't a close enough fit between the problem and the solution. This is one of the trickier aspects of ConLaw, which most people don't even grasp, but I want to stick on this. Does that make sense?
Yes. So could this, for the sake of clarification, what could they have done perhaps, just speculate?
What could who?
What could Congress have done regarding the remedy that might have been more proportional?
So what if Congress had passed a law saying that instead of suing the state for damages, right, you could have, this is a bad example because usually building permits are given with absolute discretion. That's why, let's say with the flag burning example, right? The flag burn, or there's another case in the notes, which maybe you skipped over, but was relevant as well. It's called Nevada Department of, what the heck's it called? Nevada Department of Human Resources versus Hibbs, a 2003 case. Okay? Nevada Department of Hibbs, 2003 case. It's in the notes after the case. And the law was like this. Congress passed FMLA, Family Medical Leave Act, which I'm sure some of you are familiar with, which gives people up to, 12 weeks of unpaid leave to care for yourself or a loved one, okay? This was passed under Section 5. All right? Eddie, what constitutional violation was this law intended to serve? Think about it. This one's hard. This is a much harder case than Boerne.
What constitutional violation was
Yeah.
this?
Congress said we will require employers to give 12 weeks of unpaid leave to anyone who needs it. What constitutional violation do you think they were trying to fix here? What's the problem? Anyone?
Right to procreation or something.
Close. Hugo.
Pregnant women.
Yes, explain more.
Because, when they have their kids, they have to care for them, especially in those early weeks and early months.
And what do sometimes employers do when women want to take time off?
They either fire them or they don't pay them, or, they just have them on their own. No matter no.
Okay, so Congress here said we have a problem. We have this gender discrimination, where women who do something men can't do, give birth, are not given time off. As a result, this results in gender discrimination, which violates, gender discrimination violates the
14th Amendment?
Equal Protection Clause, right? Gender discrimination, oh God.
I'm sorry.
Is this 17th Amendment?
No, I know.
16th,
I was like 16.
income tax, or what if you? So it would be unconstitutional for a state employer, such as the Nevada Department of Resources, to discriminate. So the court said like this is a very interesting opinion. It said, even though you don't have any kind of constitutional right to pay time off, this can be used to prevent gender discrimination, a prophylactic, right? This is a terrible pun, but you can use this as a prophylactic against gender discrimination. Therefore, what's the problem? Gender discrimination. What's the remedy? Unpaid time off. You see the close fit there, right? The paid time off directly connects back to the risk of gender discrimination. You see that, Eddie?
I see
You
that.
see the congruence there. That's a much
I
tighter
see
fit.
that. That's very clear.
This is the only time anything's ever been upheld, by the way. Usually stuff gets struck down to the congruence standard. This is the only time I know that something was actually upheld.
So essentially, in the city of Boerne, the zoning ordinances under which they were denied had to say something like churches should have a higher scrutiny, or something with church where it was neutral to all its buildings, but then then RFRA would apply.
Right.
In that instance, that's what you would need to get that congruency.
Yes. Yes. In that case, it would be a substantial burden. You can actually show the burden.
Even though it's neutral, because it applies to all religions, it's still
Yes.
specific.
So there's a case, some of you may have had me for property too. It was called the Church of Guru Nanak. It was a Ninth Circuit case. And the facts were like this. A group of Sikhs wanted to open up a temple somewhere in California. And first they wanted to open up in the downtown area. And the city said, oh, no, don't build it here. Build it out in the country because there's more room. Like, fine. So they go buy a piece of land in the country. Like, oh, no. Don't build it here because it's too far away from the city and we don't want things stretched out so much. So they found another site that was like huge. They're like, oh, no, you can't build it there because it might be too much noise. You have to do everything inside. They kept doing all these one after another after another. And the court found it wasn't RFRA, but it was a similar statute. They said, this is ridiculous, right? After a certain point, we think, even though on the face your zoning laws look neutral, you're targeting this faith. You're targeting these Sikhs, right? That sucks. So the issue there. So Eddie asked, what's a better way of doing it? After, in Boerne, RFRA was invalidated, right? RFRA was found, as applied to the states, unconstitutional. It's still valid for the federal government. That's why Hobby Lobby was bound by it. But RFRA was invalidated. So what did Congress do next? Anyone know? Anyone remember for property? A couple of you had me. RLUIPA. Oh, good. What was RLUIPA? This is my favorite one. Ready? RLUIPA, the Religious Land Use and Institutionalized Persons Act. So what this law did was, instead of relying on Section 5, it relied on the spending power. And it said like this: any state or instrumentality or local government that accepts federal money cannot burden religion. So rather than waiving their sovereign immunity for them by virtue of Section 5, it said, oh, if you want federal money, that's nice. That means you waive your sovereign immunity to be sued. Oh. So while they can't force them to waive it, they can bribe them. And oh, by the way, every state accepts federal money. There are very few places that don't accept federal money. So RLUIPA accomplished the major goals of RFRA, not entirely, but through the back door. Yeah, the Sikh case I just mentioned, the Guru Nanak case, that was a RLUIPA case. This also applies to prisoners. So there's a case, this term called Holt v. Hobbs, where there was a Muslim inmate who wanted to have a half-inch beard in an Arkansas prison. He sued under RLUIPA, saying, you are burdening my religion. I just want a half-inch beard. And the prison said, oh, we're afraid he can keep a razor blade in his beard, which was like ridiculous because people have hair. They keep razor blades in their hair also. So 9-0, the Supreme Court said, yeah, you can have your beard. You have your beard. Anyway. Okay, so if we can get Boerne and Section 5. Any questions of that? It's a serious incursion into state sovereign immunity to waive their sovereign immunity. To actually allow a state to be sued in federal court is a really big deal. And as you can tell, the Supreme Court is not interested in allowing this to happen. This is part of what's often called the Federalism revolution of the 1990s. So you have this in a couple different prongs, right? So we had Lopez and Morrison. These are the Commerce Clause cases, the Gun-Free School Zone case and the Violence Against Women Act case. You have New York v. United States and Prince. These are the commandeering cases, right? That the federal government can't commandeer states and individuals. And then you have these cases involving the 11th Amendment, where Congress can't waive state sovereign immunity. And these three lines of cases affected a really radical change in constitutional law. Because they basically told Congress, even if you see some sort of constitutional violation, you can't fix it however you want. And told individuals, you can't sue in federal court your state if they do something wrong. These cases were very significant. Okay. Any questions on this? All right, let's do the last case, Morrison. And we already studied this case in the context of the Commerce Clause. But this case involves a different aspect. So the first aspect of the case with Morrison. Oh, okay, so the facts of the case were like this. This is Christy Brazoncala, and she was a freshman at Virginia Tech, a state school in Virginia, and she was raped by two of her classmates. Those classmates were members of the football team. And as should surprise no one, the local police did not do a very good job prosecuting and investigating them. And at the end of the investigation, one of them got off scot-free, and the other one was like suspended for a semester. So not much, okay? She went to the Virginia police. Hey, you guys, do something. These guys should be in jail. And the Virginia police were probably townies. If you want to look at Florida State and Tallahassee as a guide, they weren't too interested in helping out. So what happened? She looked to a law called VAWA, not RFRA, but VAWA, the Violence Against Women Act. And what was VAWA? It made effectively domestic violence a federal issue. It said if you engage in domestic violence, you can sue in federal court. So who did she want to sue? She wasn't interested in suing the two people who assaulted her. She wants to sue the university, deep pockets. Now, Virginia Tech is a state school. As a state school, it's an instrument of the state. Sovereign immunity attaches. So had she gone to a Virginia court and sued the state school, she would have lost. Actually, it's a true story. The law school I went to, George Mason, was also a state school. And one of my former professors was actually sued because apparently he didn't give a student enough time on an exam for a disability or something. It was a crazy fact pattern. And she actually argued herself up to the Virginia Court of Appeals trying to change her grade. And she lost on sovereign immunity grounds, but it went up to the Court of Appeals in Virginia. So she looked to VAWA and said, you know what, VAWA, my constitutional rights were violated. I want to waive sovereign immunity of the state. I want to go to federal court. Okay? What happened here? Anyone? What happened?
She was denied.
She was denied. Why?
Because Virginia, they could handle the case.
Okay. So here is the issue, right? But let me ask this question. So go back to Casey, I'll answer this question. What was the constitutional violation that justified VAWA, the Violence Against Women Act? What was the constitutional violation that the Congress was trying to fix? Think about it. Who's usually the victim of domestic violence? Women, right? And what is the constitutional issue there with violence against women? Yeah, equal protection. Congress found that police generally don't investigate these types of crimes against women the same way they would investigate other crimes. So it wasn't that, you know, her rapist or whatever was committing a constitutional violation. The constitutional violation was that the police departments nationwide were not investigating these crimes, we're not prosecuting them, right? So let's talk about congruence, proportionality. Eddie, let's go back to you. We have the problem, right? Police are not investigating these gender-based crimes, right? What would be a proportional solution to that problem?
the police are not,
investigating gender-based crimes. What would be a constitutional solution to that problem? Think about it. Who is at fault here? The police. So who should be part of the solution? The police. Chris, your hand was up?
so,
Go ahead.
so any solution would only be restricted to apply to police.
The cause of the problem, right? The solution must fix the problem. You go.
So, maybe something that requires the state to rewrite like their investigation.
Training, right? Training guides, policies, right? They're required to understand various investigation techniques, right? So there are a lot of very narrow things Congress could have done. But Hugo, what did Congress authorize here?
Cause of action,
Against
the state.
the state. The waiver of sovereign immunity was too much. So where VAWA went too far was instead of tying the remedy to the constitutional problem of gender stereotyping, they invalidated the entire sovereign immunity of the state, right? Even if you have a couple, hokey cops, no pun intended, in Virginia Tech, right? Why does the state of Virginia have to be responsible for their mess ups? Other state, I mean, they're local cops, but I guess they're state employees, yeah. Is the state responsible then to get sued because of the behavior of a couple Beamer cops?
I don't think so, but apparently Flores do.
Vicarious
Wait.
liability.
What do you think?
Vicarious liability.
Ooh, vicarious liability. Mike, what do you think?
Well, I mean, isn't it implied in the policing power? You have to look after the health and welfare.
Yeah, but who do you sue? You sue the cop. So generally speaking, so say, police brutality, you see these stories all the time, right? Someone gets beat up by a cop during a stop. Do they sue the state or they sue the cop who did it?
It's fake.
No.
Well, they sue the cop.
How can they sue the state in the 11th Amendment? You sue the cop. Now, we have something called qualified immunity, which you'll study in other classes, but generally, the cop has to know he's violating your rights, so often brutality cases go away. But the remedy is to sue the person who messed up. Eddie?
But if the training is inadequate, why is the city or the state not responsible?
So what would happen there is that you would sue the state for failing to train. But here, you're actually suing the state for the underlying failure to prosecute, period. Again, these are all issues of how close it has to be. What if Congress passed laws saying that if there's evidence of gender discrimination, states are required to, you can sue to require states to undergo training? That would be a very narrow thing, but money damages. I mean, I'm sure she was looking for millions of dollars because this was a significant case. Money damages are a different story.
But
You go.
I guess, if she's suing the police officer, which are state officials, right? She's not gonna get money damages out of it. She's only gonna maybe just redress.
Oh no, she'll get money damage under VAWA.
Should she sue them for negligence? I mean, for the two, if she can get like an investigator to look at the entire case and say, well, look, it's a clear-cut case, and then the police officer's work was shoddy and it was negligent, therefore, here we have a case against these guys. But I guess.
So what's interesting is that it's not exactly negligence, but VAWA created a cause of action. VAWA created a cause of action to allow you to challenge the failure to prosecute gender crimes. And this was actually federal. It's not federal ConLaw. This is a federal cause of action. And I think she could go on damages and significant ones at that. Through VAWA, exactly. Everyone got that? Eddie, you still
No, I'm just
digesting?
thinking to beat a horse here. Congruence and proportionality is essentially.
But not a woman.
Right.
Too soon.
Congruence and proportionality is simply narrow and faceted. It has to be.
Tailoring.
It has to be tailored.
Yes, sir.
Narrowly faceted to the cause of the problem.
That's all.
essentially what-
Congruence proportionality is a question of tailoring. How narrowly tailored is a problem to the solution. That's how you have to think about it. So let me give you another example, right? Congress proportionality. The Voting Rights Act, which I mentioned a little bit earlier. The Voting Rights Act was enacted in 1964. Selma, right? During the height of the Civil Rights era, and was meant to resolve significant disenfranchise of blacks in the 1960s. Okay? Maps were drawn up showing in different places in the United States where the voter registration rate for various racial minorities were quite low. Okay? That was the 1960s. Eddie, let me ask you a question. Are the problems of disenfranchisement today the same as they were 40 years ago, 50 years ago?
As a white male, I would probably say no. I don't think so. But that,
Okay.
so maybe a different, much more subtle today.
So what's interesting is in a case from 2013, I can't remember what year, the last 2 years, it's called Shelby County v. Holder. The Supreme Court held that the coverage maps based on racial conditions in the 1960s were no longer current. They no longer reflected the state of race in America. Therefore, the solution of the Voting Rights Act based on those maps was unconstitutional. That those maps designed decades ago were no longer congruent and proportional to the present day situation. The Chief Justice held, quote, times have changed. So for the standard of congruence and proportionality, the Supreme Court has not just said narrow tailoring, it's a matter of time. So even if legislation was perhaps appropriate 40 years ago, it may no longer be appropriate today. And that's why the Voting Rights Act was significantly gutted in the Shelby County case. So Texas, where I think all of you live, was previously subject to one of those maps. And the map says Texas is a history of voter disenfranchisement. As a result, Texas, any changes Texas wanted to make to its voting ID laws or voter laws had to get permission from Washington, from a judge from Washington. Texas, other states challenged this, saying, wait a minute, guys, we've gotten better. Yeah, we have this bad history, but we've gotten better. You can't hold us to the standard of 50 years ago for these coverage maps from the 60s. It's no longer appropriate. It's no longer congruent and proportional. Supreme Court agreed. And they invalidated these maps. So that's why in the wake of that decision, Texas raced to enact various voter ID laws. Those laws could not have been enacted under the Voting Rights Act because they had to get permission from Washington first. But Texas was able to enact it. So a lot of people are like, wait, what's the big deal? Why shouldn't we just require Texas to have supervision? Well, I think you understand the reason, because we do have this notion of state sovereignty and state autonomy. And it's considered generally a very big incursion into states' autonomy. Tell them, here's what you have to do here, put this voting station here, do your form like this, waiving your immunity gets sued here, gets sued here. That's considered a big deal. So I think now you appreciate at least a little bit about why the voting rights decisions are important. It's not just simple as, oh yeah, let Texas go get permission from someone in Washington. Generally in our law, states can do what they want. And it's only when there's a significant problem that that immunity can be waived. What the Supreme Court held in the Shelby County decision was the circumstances were no longer sufficiently egregious to justify this subsequent incursion to states' rights. Okay. Questions? Okay. All right. So I'll look forward to all of your outlines Sunday night, and we'll come into class on Thursday and we'll discuss it, and I'll try to meet with each and every one of you in class. Okay? All right, everyone. Have a great day and a great weekend.
Thank you.
Thank you, sir.